Yes, 3 weeks time may be granted to file affidavit, my lord.
Okay, same order?
Yes, item number 40 and 41.
40, 41, for all four counter affidavits.
Yes, my lord. And item number 42, my lord.
42.
On behalf of Ina Hole, I'm mentioning on behalf of 2 weeks time may be granted. Affidavit is already filed.
So what is the stage? Let's see, it's for orders. 42?
Yes, 42. 42. 2 weeks. 42.
May it please your lordship.
I think.
Now in
let's
item
see.
number 42,
Uh,
I am also supposed to get some instruction from the Office of the Accountant General,
Okay,
and I'm also awaiting that.
you're appearing for the,
I am one of the standing counsels for the Accountant General.
okay. So let's see what is the last order. Anyway, Mr.
Joshua.
Joshua Sikwi.
Yes, Lord.
Learned Counsel for respondent number?
My Lord, I'm for the respondent number 6.
6 mentions that he is still awaiting for instructions.
My apologies, your lordship. Respondent number 5.
Okay, Learned Counsel for respondent number 5 is still awaiting for instructions, okay, whether the is still waiting for time. Yes, is still waiting for instructions from the respondent number 5 with regards to the relevant records about the pension paid to the pensioner himself or his nominee. I think that's what we have.
Yes, Lord.
Mr. So-and-so, learned government advocate, has prayed for time for filing
My
of the
lord,
counter affidavit.
I'm
Or what?
mentioning on behalf of Ina Hole.
Okay, makes mention on behalf of so-and-so, learned government,
State has already filed affidavit, my lord.
appears on behalf of, not makes mention, but appears on behalf of Miss so-and-so, learned government advocate, okay, along with Miss
Vitere for the petitioner.
V. Terry for the learned counsel for the petitioner. In view of the above, this is matter after
2 weeks, my lord.
2 weeks. It is also seen from the office note that notice issued upon respondent number 6. No, service report upon respondent number 6 is still awaited. Who is respondent number 6? Office note says respondent.
Yes, the Treasury Office Margin.
Okay. In view of the above, this is matter after 3 weeks.
My Lord.
My lord, again, I beg to mention item number 44 on behalf of Ina Hole, my lord. I'm informed that she is yet to receive instruction. So 3 weeks time may be granted to file affidavit.
Let's see, 44.
Your lordship, in item number 44, this matter is actually overdue because a traditional kingship where there is no dispute with regard to records whatsoever, that my client, the petitioner, is a right person to be appointed as the traditional king as well as the government appointment. But the matter has been
Yes.
delayed for many years.
This is regarding kingship.
Yes, yes, your lordship. Traditional
For
kingship.
which tribe is this?
Simi tribe. Simi.
Semi-tribe,
Erstwhile known as Sema tribe. Sema.
Sema tribe. Okay. And who is respondent number 4? Is it a private respondent?
Yes, your lordship.
Then the private respondent has to be present, and service of notice upon respondent number 4 is still awaited. Isn't it?
Your lordship.
Therefore, Mr. Joshua Sekwi, learned counsel for the petitioner, is present along with Mr.
Mentioning
So-and-so, who
on behalf
appears
of Inaholi.
on behalf of
Inaholi.
so-and-so, learned government advocate.
Your Lordship may kindly allow us to serve to the respondent number 4 by way of dusty service.
Okay. It is seen that service of notice upon respondent number 4 is not returned till date, and the learned counsel for the petitioner has prayed that they may be allowed to serve notice upon respondent number 4 through dusty service. Praise aloud. Notice is to be served upon respondent number 4 through dusty service. If it lists this matter after
3 weeks time.
3 weeks, affidavit to that effect is to be filed accordingly.
My Lord.
List this matter after 3 weeks.
Bless
My
your
lord,
Lordship.
I beg to mention hearing item number 46.
46.
Yes, on behalf of IME.
Ah,
Let the matter be come up after 1 week, my lord.
this is listed for hearing,
Yes,
isn't
my
it?
lord. Yes, my lord.
Mr. So-and-so, appearing on behalf of so-and-so, learned government advocate, has prayed that this matter may be listed after 1 week. Miss so-and-so, learned counsel for the petitioner, is present. List this matter after 1 week.
And item number 48 and 49.
Yes.
On behalf of Sobongla Chang. Let the matter be passed over for the day. Tomorrow.
Okay.
Lordship, it can be
So-
listed day after tomorrow, Lordship, on Thursday.
Okay. On the submission made by the learned counsels, list this matter on, what's Thursday? On 20.
20, Lordship.
I have a feeling quite a few cases have been listed for 20. Yesterday also. So make it next week. This is matter on, give me a date next week,
27, Lordship, 27.
on 27 for 2023. Yes,
Much obliged.
Lordship, I may be allowed to mention item number 3, Lordship.
3.
Yes, Lordship. Lordship, I have instruction to withdraw this case, Lordship.
Oh, why? What happened?
Lordship,
What is the case about?
it pertaining to appointment on land ownership, Lordship.
Okay, appointment concerning, okay, he had donated his land
Yes, Lordship.
and then no appointment was
No
given.
appointment, Lordship.
Now he's not interested in being appointed.
Lordship, at the moment, Lordship, I have instruction to withdraw the case,
Okay,
Lordship.
okay, maybe they're going to give him some
With liberty,
compensation.
Lordship. With liberty to approach again, Lordship.
Heard Mr.
More Jamil, Lordship.
Moy Jamir, learned counsel for the petitioner, who mentions that he has been instructed to withdraw the writ petition. And he has prayed that he may be allowed to withdraw the writ petition with the liberty to file afresh.
Lordship.
Anyone appearing on the respondent side?
I'm appearing for the private respondent, respondent number 4,
Mr.
N. Nongkumar.
N.
Lukumar.
Lukumar appears learned counsel appears on behalf of respondent number 4. In view of the submission made by the learned counsel for the petition, the writ petition number 67/2020 is allowed to be withdrawn with the permission to file afresh if so advised.
Much obliged, Lordship. Lordship, I have similar prayer for item number 23. In this case, Lordship, I have approached this honorable court for non-payment of a pending bill, Lordship. I have constructed rest house. Now, while pending this writ petition, Lordship, I have received the amount, Lordship. So I may be allowed to withdraw the case, Lordship.
Okay. Heard Mr. Mauzamir, learned counsel for the petitioner, who submits that the writ petition was with regards to,
Non-payment of pending bills, Lordship.
okay, non-payment of the pending bills by the respondents. However, during the pendency of the matter, he has been paid the pending bills. And in view of the above, he may
Lordship,
be.
I'm for the state respondent. Lordship.
Uh-huh. Okay. In view of the above, he may be allowed to withdraw the writ petition. Mr. So-and-so makes appearance on behalf of the state respondents and mentions that they have already paid all the bills.
Yes, ma'am.
Pending bills. Okay. In view of the above, the writ petition number so-and-so is allowed to be disposed, stands disposed and closed.
Much obliged.
Deeply obliged, my lord. Lordship, I beg to mention item number 45. 45.
Yes.
Lordship, this matter is analogous with other 4 matters which were listed in court number 2 today.
What is the matter about?
Lordship, the petitioners are claiming the appointment on the basis of land ownership.
Okay.
Now, Lordship,
But this thing, is this the same?
Yes.
The place, the area.
yes.
Yes, Lordship.
Okay. What are the writ petitions on the,
Lordship, the WPC
20.
20, 21, 22, and 23 is analogous with this writ petition 19 of 2023.
okay, so we'll have it listed along with 20 and 23.
Lordship, we have already sought adjournment in court number 2,
Okay.
informing the court that this WPC 19 is analogous with the rest of the writ petition
Okay.
and has been granted 3 weeks' time to file counter affidavit, Your Lordship.
Okay. Heard Mr. For the petitioner? Heard
Sentilong.
Mr.
Sentilong.
Sentilong, along with Mr.
And Angami, my lord.
N. Angami, learned government advocate for the state respondents. The learned counsel for the state respondent, learned government advocate, is it for the state respondent, mentions that there is an analogous case pending which is registered as writ petition number 20, 21, 22, and 23,
Lordship.
and has prayed that these matters may be listed together. In view of the above, list this matter after 3 weeks along with the said analogous writ petitions number 20 to 23.
Lordship.
Lordship, there is an interim.
Meanwhile, the interim order passed earlier shall continue till the next date.
Deeply obliged, my lord.
Much obliged.
May I please, Your Lordship? Lordship, may I be pleased to mention item number 1?
1.
Yeah, 1 and 2 both, Your Lordship. Let the matter come up next week, Your Lordship. I'm having some personal difficulties today, Your Lordship.
Okay, heard Miss
Livika, Your Lordship.
Livika, learned government advocate for the state respondents, who has prayed that this matter may be listed next week since she is facing some personal difficulties. Mr. C.T. Jamir, learned senior counsel for the petitioner, is present. In view of the above, list this matter next week.
Your Lordship, I have a similar prayer for 2 also, Your Lordship.
Yes, same order for 2. But who is appearing for the petitioner in number 2?
Lordship.
Okay, you'll mention his name, okay? Yes.
Your Lordship, item 14, Your Lordship.
1-4,
Yes, Your Lordship.
yes.
Your Lordship, here, the matter has been endorsed to me and I have to take a fresh instruction, Your Lordship. So
Okay.
3 weeks may be granted, Your Lordship.
Are you the CGC?
No, I'm for the state, Your Lordship.
State,
Yes,
okay.
Your Lordship.
Heard Ms. So-and-so, learned government advocate, who mentions that this matter has been handed over to her recently and has paid for time for filing the counter affidavit for the state respondents. Is it? Mr. Fuseko Forte appears on behalf of the petitioner, learned counsel, okay, appears on behalf of the petitioner. In view of the above, anyone else appearing?
My lord, I filed my counter.
14.
Yes, my lord.
Yes, your 4 respondents number?
The CGC, my lord.
Mr. So-and-so,
Z.N. Moli, my lord. Z.N. Moli.
so-and-so appears on behalf of respondent number, your private respondent or what?
My lord, Union of India, my lord.
Okay, appears on behalf of the Union of India, okay. List this matter after 3 weeks.
Lordship is an interim.
Meanwhile, the interim order passed earlier shall continue till the next date.
Obliged, my lord.
Your Lordship, I also beg to mention hearing item 50 and 51. Your Lordship, let it come after a week, Your Lordship.
Okay, heard Ms. So-and-so, learned government advocate for the state respondents, who has prayed for adjournment since she's facing some personal problems. Okay.
Yes.
Mr.
Lordship, I'm appearing on behalf of Tongbok Ponganar.
so-and-so appears on behalf of Mr. Topok Pongener, learned counsel for the petitioner. In view of the above, list this matter after, let's make it 2 weeks, after 2 weeks.
Much obliged.
Lordship, I beg to mention item number 47. I'm appearing on behalf of my senior TKG. He's in
Okay.
disposal currently, list the matter after 1 week.
Who's appearing for the petitioner? 47?
My lord, I'm appearing for the petitioner, my ladyship.
Okay. Keith, are you for the private respondent?
Respondent number 5,
5. Okay. Mr.
Makaka.
Mahaka makes mention on behalf of his senior, Mr. T. KG, learned counsel for respondent number 5, praying for adjournment since his senior, Mr. T. KG, is indisposed. Ms. Shori, okay, learned government advocate for the state respondents is present, along with Mr.
N.
Yes,
Lokumar.
and Lokumar, learned counsel for the petitioner. In view of the above, list this matter after 2 weeks?
1 week.
After a week, man.
Okay, after 1 week.
Obliged.
Lordship, I'm just informed that item number 4 has been taken up when I was taking up a matter in the other courtroom. Item number 4. I'm for the petitioner. My humble prayer is that the interim order passed earlier may continue.
Okay, 4, we have adjourned the matter. Interim order passed earlier shall continue till the next date.
Lordship, if I may, it has been more than 2 years now, and the government, the respondents are yet to file the affidavit in opposition. Last chance may be given, Your Lordship.
I think 2 weeks' time or something time has
3
been
weeks' time was
3
given.
weeks has been given. Okay. Failing which, appropriate orders may be passed. Okay, let's see the matter.
Okay, much obliged.
Yes, Your Lordship. Lordship, I beg to mention item number 25, Lordship. Lordship, here I'm appearing for respondents 6 to 37, the private respondents. Lordship, if I may be granted 3 weeks' time to file my affidavit in opposition.
25, I think we have adjourned the matter where the state respondents have prayed for time. Isn't it 25?
No.
No? Okay. Miss
Miss Lucino for
Lucino
respondents 6 to 37.
appears on behalf of respondent number 6 to 37 and has prayed for time for filing of the counter affidavit. Mr. So-and-so appears. Your name?
Pane Konyak.
Yes, appears on behalf of the petitioner. In view of the above, list this matter after
3 weeks.
3 weeks.
Much obliged.
Obliged, my lord.
Any other matter?
For admission, item number 7.
Yes.
Pleadings are completed, so let it come up in the hearing.
For admission hearing? Is it? See here, last date also it says it may be listed for admission hearing. Isn't it? So it's ready for admission hearing, just for admission today. On the prayer made by the councils for both the parties.
Not what the response.
Okay, on the prayer made by the learned counsel for the petitioner, Mr.
I am the long, sir.
Ian DeLong, lists this matter after 2 weeks.
My lord.
After 2 weeks.
Same with the item 8.
Item 8. What is the matter? Now in item 8, there's an IA, isn't it?
For condemnation of.
My lord, that has to be considered along with the writ petition.
Why?
They are contending that
IA is for delay of how many days?
13 years.
13 years.
Yes.
So I think we should dispose of the IA first, and then we'll see whether the writ petition has to be considered, isn't it?
My lord, it can be.
See,
Because
whatever
the question is this, my lord.
13 years is a long time.
Yes.
So if your IA is disposed, we don't have to consider the writ petition.
My lord, the question is this. The petitioner is a Assam Rifle personnel.
Uh-huh.
He was penalized under Army Act. So the question of Delhi in the illegality, because somebody who is subject to Assam Rifles cannot be punished under Army Act. Because
But why has he approached this court after 13 years? That's the main issue we have to see,
My
isn't
lord.
it? Oh. So are we going to have a hearing on the IA, or are you going to pray for adjournment?
let the IA be heard day after
Today?
tomorrow. Yes.
13 years, you'll have to give a reason. Whatever the writ petition is about, 13 years is a long time. So we have to see whether we're going to consider your writ petition or not, isn't it? Heard Mr. Imti Longchar, is it?
My lord.
Learned counsel for the applicant in the IA, okay, who has prayed for another date. Mr. So-and-so, learned government advocate is present.
Central Government Study Council.
Pardon?
CGSC.
CGC.
Okay, learned CGC for the respondents is present. This is matter. When
Day
do
after
I-
tomorrow.
On Thursday, I think we have fixed a lot of cases. 24, isn't it?
Next week,
This is matter next week.
March of last.
Yes.
Item number 10.
Yes. May I please, Your Lordship? Yes, Your Lordship. By filing the present writ petition, I'm praying for a minimum scale of pay.
Uh-huh.
And Your Lordship, the petitioner in this case, she was appointed as sweeper on casual basis under the Department of District Agriculture Officer. And she was appointed on fixed pay, Your Lordship. Her
When was she
appointment,
appointed? When was she appointed?
she was appointed in 2006, 19 October 2006.
19 October 2006. Okay.
Yes, Your Lordship.
As a sweeper,
Yes, Your Lordship.
having a fixed pay,
Yes, Your Lordship.
Oh,
Fixed
yeah.
pay of rupees 2,000.
2000. Okay. Then
Her
what
appointment
happened?
order is in Annexure 1, page number 8.
Yes.
Yes, may I read it, Your Lordship? In the interest of public service, Srimati so-and-so, wife of late so-and-so ex-driver, is hereby appointed as sweeper on casual basis under the establishment of DAO Kohima for a period of 5 months with effect from 1/10/2006 to 28/2007 at fixed pay of rupees 2,000 per month against Sri so-and-so LDA casual under the agronomist SSF Merapani resigned. Her pay wages will be paid from the works program against so-and-so, Your Lordship. And her service has been kept extending from time to time, Your Lordship. And Your Lordship, Annexure 5, page number 14, if Your Lordship may kindly come. She has made a representation to the department to grant her scale of pay. On 3rd March 2021, Your Lordship. So, however, it was not considered. So, Your Lordship, being aggrieved, the petitioner has filed a writ petition before this honorable
Okay.
court.
What is the ground for not considering?
Your Lordship, she has not received any information in regard to that.
Okay. So she has filed a representation
Yes.
which has not been replied.
Yes,
No,
yes, Your
nothing.
Lordship. Yes.
Yes.
So, being aggrieved, she has approached this honorable court. And Your Lordship, if, as per the RTI reply made by the department, Your Lordship, which I have annexed in my affidavit in reply. Annexure 18, Annexure 8, page number 18, in my affidavit in reply, Your Lordship. As per the information furnished by the department, Your Lordship, as many as 12 employees who were similarly situated with the petitioner.
Page
present
12,
petitioner.
is it?
Yes, page 12.
Page 12.
Yes, Your Lordship.
Yes.
Page 12. These are the employees who are regularized by the department, Your Lordship. And among these, 6 of them were junior to the petitioner, Your Lordship. So, Your Lordship, it appears that the department has adopted a pick and choose policy, Your Lordship. And similarly situated employees have been discriminated.
So let's come to page 12. In your page 12, 12 persons have been appointed, you're saying. Is
Yes,
it?
Your Lordship. Yes, Your Lordship.
When was the appointments? Number one was appointed in 2001.
One.
So you can't say that she is junior, isn't it?
Yes, Your Lordship.
Then number 8, serial number 7, 8, 9, 10,
Yes, Your Lordship.
and 12. These are all senior to her, isn't it?
Yes, Your Lordship.
So how many people junior to her, according to you, have been regularized? 1,
Yes, Your Lordship.
2, 3, 4, 5, and 6. 6 persons, is it,
Yes.
from 12?
Yes, serial number 2, serial number.
And the appointments is the same
Yes, Your Lordship.
on fixed pay?
Yes, I believe so. Because if Your Lordship may come to page number 8, next year 8, I have sought the following information, Your Lordship. If I may be allowed to read this.
Yes, yes.
List of employees who were appointed on casual, ad hoc, word charge, etc. basis by your esteemed department and who were subsequently regularized, clearly indicating their date of appointment, name of the post, and date of regularization. The list of casual, ad hoc, word charge, etc. employees who were appointed on fixed pay basis by your esteemed department and subsequently upgraded to scale of pay, clearly indicating their date of appointment, name of the post, and date of award of scale of pay, Your Lordship. However, the serial number 2, the information with regard to those employees who were appointed on fixed pay and were subsequently upgraded to scale of pay, this information was not furnished, Your Lordship. The department has only furnished the information of those employees who were regularized. So, Your Lordship, I believe that it is my humble submission that those employees were given scale of pay and then subsequently regularized.
This is the list given,
Yes, Your Lordship.
not what you asked for.
Yes, only those employees who were regularized were the list given by the department.
Okay. But not those who were
Upgraded
employed
to
as
scale of pay.
fixed pay.
Yes, Your Lordship. Appointed on fixed pay and then subsequently upgraded to scale of
Okay,
pay.
so your query has not been answered yet.
Yes, Your
isn't
Lordship.
it? Oh,
Only those employees who were regularized was furnished.
okay. Yes. Anything else?
So, Your Lordship, I may be allowed to place a reliance on the decision passed by this honorable court, Your Lordship. Your Lordship, this writ appeal was filed by the state respondents. In the earlier writ petition, Your Lordship, the learned single judge has given a direction to the state respondents to grant minimum scale of pay to the petitioner, Your Lordship, and being aggrieved, the state has filed the present writ appeal, which was dismissed by this honorable court, by the division bench of this honorable court.
But isn't this concerning discharging of the same work, equal pay?
Yes, Your Lordship.
So are you saying that there are some persons who have been given equal work, but the pay is different in your case?
Yes, Your Lordship.
See,
She's
if-
also performing the same duty and functions as any other regular employee are performing, Your Lordship.
Okay. And the others who are performing the same work, have they been regularized, or have they been given scale of pay? I mean, if
No,
you're
Your Lordship.
relying on this judgment, I think the facts of this judgment is slightly different from yours.
Yeah, maybe, Your Lordship, but
What is
the
your
same
point
principle may
then?
be applied to my case
Okay,
in this
give
present
the
petition.
paragraph, read the paragraph where it applies to your case also.
Your Lordship may kindly come
Because,
to
yes,
paragraph 15, page number
1,
15.
5. Yes,
May I read it to you?
yes.
Furthermore, we are in respectful agreement that there is no quarrel with the law laid down by the Honorable Apex Court that equation of post and determination of pay scale is the primary function of the executive and not the judiciary, and therefore the courts ordinarily will not embark upon the task of job evaluation, which is generally left to the expert bodies. It is, however, well settled that the principle for equal pay for equal work is applied where there is complete and wholesale identity between two groups of employees discharging the same work, and even a daily wage employee who is performing duties similar to that of the regular employee is at least entitled to receive the minimum pay scale as paid to a regular employee. In the instant case, the respondent who is serving as a sweeper on contingency basis on a fixed pay of Rs 3,450 per month has satisfactorily discharged her responsibilities of explaining that she performs the same work, duties, and responsibilities as discharged by the regular sweepers by making clear averments to the fact that which has not been disclosed by the state appellant. We are therefore of the considered view that the respondent performs the same nature of work and duties as that discharged by regular sweepers and is accordingly entitled to equal pay as that received by the regular sweepers. In view of the discussion made above and the law laid down by the Honorable Apex Court and taking into consideration all attending facts and circumstances, we find no infirmity with the order dated 14/6/2002 passed by the learned single judge in WPC number so and so. The state appellants are accordingly directed to carry out the order dated so and so passed by the learned single judge within a period of 60 days from the date of passing this order. Appeal dismissed.
So you're saying that regular sweepers, is it? Is
Yes.
that in your petition?
Yes, Your.
Where are the other regular sweepers? Sweepers. Where are the other sweepers who have been given regular pay? Have you
Your
mentioned
Lordship,
that?
as per the information furnished by the through the RTI, those
Okay.
employees who were regularized were truck driver, handyman, but there is no sweeper.
There's no sweeper there.
Yes, Your Lordship.
So,
And Your Lordship, I may also be allowed to rely on.
see, your RTI, which
Yes.
information that you received, you should be getting the list where regular sweepers
Yes, Your Lordship.
have also been given a scale of pay, isn't it?
Yes, Your Lordship. But with regard to that information, they have not furnished.
So what do? You ask again? See, if you're going to base your argument on this case is concerning equal work, equal pay.
Yes, Your Lordship.
Okay. So on reading this judgment, it seems that this court came to a finding saying that other sweepers who were also given appointment have been given regular pay. So because of that, she is also entitled.
Yes, Your Lordship.
Now, if you're going to base the argument on this, then you have to show that there are other employees who have been given appointment as what work charge or whatever, but they have all been given what scale of pay, and you have not been given. Something like that has to be
Yes, Your
there.
Lordship.
But the list which you have shown to me through RTI, there's no sweeper here.
Yes, Your Lordship.
So what do we do?
Your Lordship, I may be allowed to rely on the decision passed by the Honorable Supreme Court, which I have reproduced.
okay, yes.
Which I have reproduced in my affidavit in reply.
Okay.
In paragraph 4. If Your Lordship may kindly turn to page number
Wait,
3.
One minute. Let me turn to the page. Yes.
Yes, page number 3, Your Lordship. I may be allowed to read from paragraph 2, from the next paragraph. Further, it is no longer res integra that all work charge casual ad hoc employees are entitled to draw wages at a minimum of pay scale extended to regular employees. However, thus far, the petitioner has been compelled to work under fixed pay. Petitioner may be allowed to rely upon the decision of the Honorable Supreme Court in the State of Punjab versus Chakchit Singh, 2017 1 SSC 148, relevant part of which is reproduced here in below for Your Lordship's ready reference. There is no room for any doubt that the principle of equal pay for equal work has emerged as an interpretation of different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court and constitutes law declared by this court. The same is binding on all the courts in India under Article 141 of the Constitution of India. The parameters of the principle have been summarized by us in paragraph 42 here in above. The principle of equal pay for equal work has been extended to temporary employees, differently described as work charge, daily wage, casual, ad hoc, contractual, and the like. In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than any other who performs the same duties and responsibilities, certainly not in a welfare state. Such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family, at the cost of his self-respect and dignity, at the cost of his self-worth and the cost of his integrity. For he knows that his dependents would suffer immensely if he does not accept a lesser wage. Any fact of paying less wages as compared to others similarly situated constitutes an act of exploitative enslavement emerging out of domineering position. Undoubtedly, the action is oppressive, suppressive, and coercive as it compels involuntary subjugation. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the concerned temporary employees in the present bunch of cases would be entitled to draw wages at the minimum of pay scale at the lowest grade in the regular pay scale, extended to regular employees holding the same post. And Your Lordship, I may be also allowed to take Your Lordship to Annexure 7, page number 17 in my writ petition, Your Lordship. The office memorandum dated 17 March 2015.
Yes.
Your Lordship, para 1, regularization in service. All existing work charge and casual employees of various departments who are enjoying scale of pay and have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of the post into regular ones personal to them and subject to fulfillment of conditions as indicated below. Your Lordship, so unless the petitioner is granted scale of pay, even if she completes 30 years, she will not be eligible for regularization, Your Lordship.
How many years have she worked?
More than 15 years.
2006. So you're praying that she be given a scale of pay?
Yes, Your
Said-
Lordship. Presently, she is receiving a salary of 5,280, Your Lordship, which is hardly sufficient to maintain herself. And she is a single mother, Your Lordship. She has to look after her children.
So you're waiting for a reply to your representation, which
Yes,
has
Your
not been
Lordship.
replied yet.
Yes, Your Lordship.
So won't it be appropriate if you wait for the reply? Anyways, let's hear okay, now.
May I please, Your Lordship?
Yes.
Lordship, the petitioners has already read out the order by which he is appointed. However, Your Lordship, to show the exact position on what basis the petitioner is appointed, allow me, Your Lordship, to read the order dated 19th October 2006, which is at page 8 of the writ petition.
Yes.
If I may be allowed to read, my Lord.
Yes.
Order. In the interest of public service, Srimati Anitoli Asumi, wife of late such and such, ex-driver, is hereby appointed as sweeper on casual basis under the establishment of DAO Kohima for a period of 5 months with effect from 1/10/2006 to 28/2/2007 at a fixed pay of rupees 2,000. This is the status as to how the petitioner is appointed initially. Thereafter, Your Lordship, on the next page, a similar order is issued by order dated 24 May 2007, whereby the petitioner stand on the same footing. On the next page, Your Lordship, page 9. Now, Your Lordship, having seen the order dated 19/10/2006 and 24 May 2007, it is clear that the petitioner is appointed on a fixed pay basis.
Yes.
Now, Your Lordship, there is no policy as of today framed by the state government with regards to regularization of the fixed paid employees. The petitioner has read out the office memorandum, which is annexed as Annexure 7, page 17, and has rightly pointed out, Your Lordship,
Yes.
page 17, my
Oh,
Lord.
they have to have scale of pay.
Yes,
isn't it? Huh?
yes, Your Lordship. However, here, these particular notifications affect the fixed paid employees on one ground. That is the revision of pay.
Okay.
Revision of pay, Your Lordship. Now, your revision of pay for the fixed paid employees, Your Lordship will find on page 19. Page 19, Your Lordship.
Yes.
This is 2, Roman letter 2, revision of rate of wages at fixed paid, work charge, and casuals contingency employees. Now their pay has been revised through these notifications. And Your Lordship, the petitioner also has admitted that after this notification came into existence, her pay has been revised as per the notification, as per this particular office memorandum, which again shows that she is on a fixed paid employee. Now, what happened, Your Lordship, is this. Is there no provisions that a person who is initially appointed as a fixed pay employee will ever get a chance to be regularized in their lifetime? That is the question, Your Lordship. Now here, Your Lordship, under various departments, under the government of Nagaland, the department is maintaining a list, a tentative seniority list of the fixed paid employees, work charge employees working under the department. Now, Your Lordship, one such list is maintained by the department pertaining to the person who are exactly on the same footing, Your Lordship. I have annexed that in my affidavit in opposition, Your Lordship. At page 6. My affidavit in opposition.
Yes.
At page 6, Your Lordship. If I may be allowed to read the heading. Tentative seniority list of grade 4 casual employees as on 4/2/2021. There are as many as 22 fixed grade 4 employees, Your Lordship, which, if you see at column 1, 2, 3, 4, and 5, designation, are old sweepers and Mali. Sweepers and Mali, Your Lordship.
Yes, yes.
Now, Your Lordship, the petitioner has referred.
Okay, is her name here in this page
Yes,
6?
yes.
What's
Your
serial
Lordship,
number?
you'll find the
She's-
petitioner's name as serial number 21.
Okay.
21. So, as per the latest tentative seniority list, the petitioner is at serial number 21. Serial 21, my lord.
Yes. Go ahead. I'm listening.
Now, Your Lordship, the petitioner has gone to the RTR reply that was given by the department, stating that a person who is junior to her, service has been regularized.
Yes.
By reading out the list which is there at page number 12. If I may be allowed to refer that page again, Your Lordship. Page number 12. Of their
Page
affidavit.
number 12 of her.
Affidavit in reply, my lord.
Okay, affidavit in
Reply,
reply
Your
by
Lordship.
the
By the
petitioner.
petitioner.
Yes. Yes.
Now, Your Lordship, she has read this particular page by stating that a person who is junior to her has also, the service has been regularized. Your Lordship, allow me to read column number 2, designation. Serial number 1 is a tractor driver.
Yes.
Serial number 2, 3, and 4 is a driver. Serial number 5, mechanic helper. Serial number 6, tractor handyman. Serial number 7, handyman. Serial number 8, driver. Serial number 9 and 10, handyman. Serial number 11 and 12, driver. Now, Your Lordship, a person appointed on a particular post, can his service be regularized in another post?
Yes.
Because these are the posts which the petitioner is never holding. In other words, it's like coming to this court and showing a document by saying that I am appointed as a driver. However, there is a post vacant for a post of engineer. I should be regularized in that post. Is that practical submission, Your Lordship?
Yes.
If at all the petitioner is supposed to be regularized, he or she has to be regularized on the same post that he is holding. He cannot be regularized on another post. Now, as stated by me, Your Lordship, the petitioner service will definitely be regularized as per the availability of the vacancies under the same post and strictly maintaining the seniority list.
Yes.
Now, Your Lordship, the petitioner has again referred to the citation which relates to minimum scale of pay.
Yes.
Minimum scale of pay. Your Lordship may kindly refer the prayer made by the petitioner in the writ petition, which is at page 6.
Yes.
I may be allowed to read. A writ order direction should not be issued to regularize the petitioner against the lowest scale of pay permissible in grade 4. Whereas she claimed that she should be given minimum scale of pay. She is taking another stance now.
So how is this lowest scale of pay given?
Your Lordship, that would depend on after the petitioner is regularized. Then, as per the ROP that is applicable to them, the petitioners will be paid as per that ROP on a given scale of pay. Now, to even regularize the petitioner at this juncture, Your Lordship, she will have to supersede. She will have to supersede as many as 16 other senior who are similarly situated with her. Will it not amount to perpetuating an illegality, regularizing her service when she is placed as serial number 21 in the list?
Yes.
So, Your Lordship, the petition has got no merit, and it should be dismissed, Your Lordship, for the fact that the petitioner now cannot take a stand that a minimum scale of pay has to be given to him because no such averment has been made in the writ petition at all. Neither that is the prayer of the petitioner in the writ petition, Your Lordship. Just by citing some citation, Your Lordship, the petitioner cannot take a different stand now, because that is not what she has averred in the writ petition. Neither that is her prayer in the writ petition, Your Lordship. Petitioner service will be regularized as per the vacancy available, and that is what we have stated in our affidavit in opposition, Your Lordship.
Yes.
That her service can be regularized and will be regularized as per the vacancy available and as per the tentative seniority list. As of today, Your Lordship, if you are to regularize her service, then, Your Lordship, it will be amounting to perpetuating an illegality for the fact that as many as 16 others senior who are similarly situated, Your Lordship, will have to be superseded for her regularization, Your Lordship. And therefore, the petition has got no merit and should be dismissed, Your Lordship.
Yes. Anything else to say?
Yes, Your Lordship.
Yes.
As per the RTR reply, Your Lordship, which I've relied. And Your Lordship, as per the scheme for regularization of work charge and casual employees, Your Lordship, the scheme does not talk about sanction post. It talks about regularization by conversion of the post into personal one similar to them, Your Lordship. It does not talk about sanction post, Your Lordship. And Your Lordship, as per the RTI reply that I have relied, Your Lordship, these are the grade 4 employees, which means it is similarly situated with the petitioner, Your Lordship.
Okay.
The designation may be different, Your Lordship.
Yes. Anything else?
Yes, Your Lordship, their designation may be different, but they are all grade 4 employees. So, Your Lordship, they are similarly situated, Your Lordship. So, my humble submission is that, Your Lordship, this, as per this RTI reply, those employees who were junior to the petitioner were also regularized, Your Lordship. And, Your Lordship, my humble submission is that unless the petitioner is given a scale of pay, Your Lordship, her service cannot be regularized, Your Lordship. That is my humble submission.
Okay, so you're saying unless she's given scale of pay,
Your Lordship.
her service cannot be regularized.
Yes, Your Lordship.
So what are you praying for? You're praying that she be given a scale of pay or
Yes,
that her
Your Lordship.
service be regularized?
Against the lowest scale of pay and regularized.
So which comes first?
Regularization should come first, Your Lordship.
You're saying that she be given a scale of pay so that her services can be regularized, isn't it?
Lordship, because in my prayer, Lordship, which I've stated that to regularize the petitioner against the lowest scale of pay permissible to grade 4 employees.
Okay. Anyways, I will note down your submissions. And it is seen here that you have made an application before the state government.
Yes, Your Lordship.
Okay, well, where's your application? Just come back to that.
Page 14, my lord.
And you have not received any reply to that, isn't it? Here you have prayed for grant of scale of pay.
Yes, Your Lordship.
Okay, so you want the scale of pay first before regularization, is it? Anyways, having heard both the parties,
Lordship,
let me note down your submissions. I have heard both of you. Then this writ petition will be dismissed, okay, with a direction to the state government to respond to your application which has been made. That is in page 14. You have not received any reply to that. Let the state respondents
Lordship.
reply to this. And if she's unhappy with the reply,
Lordship.
whatever the reasons be, then she can come to the court again. Okay. If she finds, so the reasoning given by the state respondents, because this has not been addressed to yet, isn't it? There's an application made by her to the state respondents.
Yes.
Where she has prayed for grant of scale of pay.
Yes, yes.
There's no response to that. It's still
Lordship,
awaiting for some reply, isn't it?
Before we could reply, she has approached this court.
Yes. So we'll dismiss the writ appeal, directing the state government, okay, to reply to this first. We'll dispose of the writ appeal, directing the state government to respond to the application which has been made by you. Then depending on the reply, you can either be satisfied or it might be granted, whatever. Then after that, I think it is premature for you to come to this court at this stage when this application is still awaiting. You got my point? Okay. So heard Miss
Vitere.
D. Terry, learned counsel for the petitioner, who has filed this writ petition under Article 226, is it? Yes.
If I may be allowed to make
Yes.
a short
Yes,
submission
yes,
on that
yes, yes,
representation.
Yes.
Lordship,
And you reply her.
yes, even if that disposal of this representation is concerned, Your Lordship, it will still be the same for the fact that, Your Lordship, the government, as I have explained, and we have explained everything in our affidavit in opposition, Your Lordship, the government is still going to take the same stand.
So then let them take, it's okay.
Now, since
Isn't it?
because we have already brought everything on record, Your
Because
Lordship, before the court.
there is something pending, and it's not be appropriate for the state government, for the court at this stage to simply make the decision with regards to her application made. Okay, so we'll pass the order, whatever the application.
I leave it to my
Okay,
lord. I
okay.
leave it to.
This is application filed under section 226 of the Constitution of India for issuing the appropriate writ against the state respondents. Full stop. This case of the petitioner is that she was appointed as a sweeper on casual basis under the establishment of DAO, Kohima for a period of 5 years at a fixed pay of rupees 2,000 only per month, which was extended again on 24th May 2027, is it?
Yes.
From 1/4/2007 to 39/2007. Any further extension after that? So that's a period, is it?
Yes, Your Lord.
Thereafter, she had written to the Directorate of Agriculture, Nagaland, Kohima, praying that since she was appointed as a sweeper on casual basis for a period of 5 months, and thereafter her service has been extended from time to time, wherein her salary was increased to rupees 5,280. Is it? Wide notification dated 13/11/2019. She had prayed for grant of scale of pay. In her letter dated 03/03/2021. However, since she did not receive any reply to her letter dated 03/03/2021, she has approached this court by way of the instant writ petition. The learned counsel for the petitioner submits that the petitioner had received information through RTI that persons who were also appointed as grade 4,
Yes,
is
Your
it?
Lordship.
And appointed later than her have been granted, have been regularized. Okay. and has annexed the information as Annexure 9 in her affidavit in reply. She has also cited the decision of the division bench of this court in State of Nagaland and others versus Hisheni Sumi, dated 14/09/2022 in case number WA 25/2022. Wherein the court, on the basis of equal pay for equal work, held that regular sweepers are entitled to equal pay as that received by regular sweepers. And also cited the decision of the apex court in. Now, in these matters, okay, when you cite decisions of the apex court, you should have this full judgment with you with the citation so that we have the full text, not bits and pieces which you want to refer to.
Yes,
Okay, because the case, the facts of the case could be different also, isn't it? Little bits of pieces. It's okay for you to mention it in your
Yes, Your
affidavit in reply, but I should have the text with me also so that I can have a look. Isn't it the full judgment? Okay. She has also cited the decision of the apex court in State of Punjab versus Jagjit Singh, 2017, 1 SCC 148. Then Mr. Mr. N. Angami.
Lordship.
Mr. N. Angami, learned government advocate, on the other hand, submits that on perusal of the appointment order of the petitioner, it is clear that she has been appointed with a fixed pay on casual basis. Wait, before that, I forgot to record one of her submissions. Before saying that cited the cases, okay, you will mention that the learned counsel for the petitioner submits that the petitioner is entitled to be regularized as per the office memorandum dated 17 March 2015. Okay, issued by the Personnel and Administrative Reform Department, Government of Nagaland. Yes, then we'll come back. Learned Council submits that, Learned Council Government Advocate, okay, submits that has been appointed on casual basis with a fixed pay. Okay. And that the mentioned office memorandum dated 17th March 2015 provides for regularization in service with regards to work charged and casual employees who are enjoying scale pay. Okay?
Yes.
While the instant petitioner is employed on a fixed pay. He further mentions that with regards to revision of rates of wages of fixed pay work charge and casual / contingency employees, the pay of the instant petitioner has been revised. Okay, and she is now enjoying the pay of rupees 5,000 something.
280. 5,280.
Rupees
280.
2,080, whatever the amount is, okay? As per the notification of, as per the office memorandum dated 17 March 2015, okay? And therefore, she cannot claim for the regularization in service since she is having a fixed pay. She further submits that with regards to the regularization of employees, work charge employees, okay, it has to go as per the seniority. And the learned government advocate has led this court to the list provided in Annexure A of the counter affidavit, which is the tentative seniority list of grade 4 within brackets casual employees as on 4/02/2021, showing that the instant petitioner is listed at serial number 21. Full stop. The learned government advocate mentions that the petitioner will be regularized as and when her turn comes as per the seniority, tentative seniority list, and that she cannot supersede as many as, how many?
16.
16
Other
other employees
Similarly-
who are
similarly-
similarly placed employees.
Lordship.
Okay, other similarly placed employees, which would be against the interest of justice.
Lordship.
Okay. Any other point which I've missed out?
Lordship, with regards to the minimum scale of pay
Yes.
that the petitioner has referred to,
Uh-huh.
that is not the prayer made in the writ petition, neither any averment as such as is made by the petitioner in the writ petition.
Okay.
And therefore, she cannot take another stand now, Your Lordship.
The learned government advocate also mentions that the counsel for the petitioner has prayed for minimum scale of pay, which was not mentioned in the
Writ petition,
writ petition.
neither that is the prayer made in the writ petition.
Okay. And has not made any such prayer in the writ petition.
Lordship.
And therefore, she cannot take that stand
Seeking minimum scale.
seeking minimum scale of pay, which is reflected by her in the judgments cited
Lordship.
by the counsel for the petitioner. Having heard the submissions made by both the parties, this court finds that the petitioner had made an application to the Directorate of Agriculture, Nagaland, Kohima, praying for grant of scale of pay. And that before she had received any response from the state government with regards to the letter, with regards to her letter dated 03/03/2021, she had approached this court praying for regularization and has also submitted that she also may be granted minimum grant of scale of pay. The court, having considered the submissions made by both the parties, finds that the petitioner is premature in filing the writ petition at this stage when her prayer in the letter dated 03/03/2021 has not been addressed by the state respondents.
Your Lordship, sorry for interruption, but I filed the writ petition after making the representation after 30 days, Your Lordship. After,
Okay.
Yes, even after 30 days, the department has not intimated.
Okay. Has not addressed to the representation made by so and so, even after 30 days, after which he had filed the writ petition. So what does the 30 days, does it implicate anything?
Yes, Your Lordship, I have to wait for at least 30 days, Your Lordship, for the department to reply.
Okay. Even after waiting for 30 days for the department to reply. Okay. In view of the above, this court finds it fit to pass an order for the department to consider whether there is any substance in the application made by her in her letter dated 03/03/2021 and file a reply within, how long will it take? 2 weeks?
No, Your Lordship, at least a month time, Your Lordship.
Okay.
4 weeks time.
Within 4 weeks. Within 4 weeks. And this writ petition accordingly stands disposed with the above direction.
Lordship.
Yes, Your Lordship, I may be given the liberty to approach this honorable court again.
That liberty is always there, Your Lordship, if she is.
This
Lordship,
thing, then
yes.
if you are
If she is
unhappy, you
aggrieved by-
come,
yes, yes.
you study the reply given by the state government.
Lordship.
And then if you find that the reasons given by the state government for rejecting or allowing, we don't know how it's, then based on that, you can have a case, isn't it? Based on the reply.
Lordship,
Because certain grounds will be given for as to why it has not been considered, it has not been allowed or
Yes,
allowed. I'm not going to
yes,
say that
yes,
because
yes.
anything can happen.
Yes,
Okay, it may be allowed, it may not be. Then based on that reply, you can have a ground to come. That's up to you then. Isn't it?
Lordship, instead of 4 weeks, if it can be made 6 weeks, Your Lordship, in order to avoid any complications
Okay,
in
within
future.
6 weeks.
Lordship.
Fine.
Deeply obliged, my Lord.
Item number 17.
Yes. I think. What was that which we just decided? Okay, yes, 17. Similar type, regularization.
Yes, Your Lordship, I'm seeking for regularization. However, today the government advocate is not present.
Okay. Who is the government advocate? Someone is present here. You're for the private respondent?
Lordship, I'm for the Accountant General.
Accountant
Respondent number
ge-
5.
5. Okay. Who's appearing? You're appearing?
No, Your Lordship. In fact, the brief is handled by my colleague, Mrs. Lucy, Your Lordship.
Okay.
Pleadings competition.
And we'll fix another date.
Your
Miss?
Lordship, pleadings are completed, so it may be fixed for admission hearing. A date may be fixed, Your Lordship.
Okay. Pleadings are complete? Are you sure?
Yes, Your Lordship. Both the respondents have filed their
Okay.
affidavit.
On the submission made by the learned counsels for the parties, it appears that pleadings are complete. In view of the above, the matter may be listed for admission hearing after 2 weeks.
On 24th, Your Lordship, this month.
Make it 2 weeks, after 2 weeks. Okay. Yes.
Oblige.
Item number 31.
Yes. What is 31? Counter affidavit. Here it says that counter affidavit, state respondents have prayed for time for granting of filing of counter affidavit. Who is appearing for the state respondents? Item number 31. Yes. Who is
Lordship,
appearing in this case? Counter affidavit has to be filed as per the last order.
Lordship, I'm not in this case.
Who is in this case?
Lordship,
Who is for the petitioner? None is appearing? Okay. Anyone for the petitioner? None appeared for the parties on call.
Lordship, I'm for the state, Your Lordship.
None appeared for the petitioner on call, while Mr. So-and-so,
Government.
learned government advocate, appears on behalf of the state respondents. In view of the above, list this matter after 3 weeks.
Obliged, my lord.
Item number 38.
Yes, 38.
Yes, may I please, Your Honor.
Oh, 3 weeks' time is granted for filing counter affidavit. This is the last court date. Who is appearing for the state? 38. Yes.
Yes, Lordship, I'm agreeing. Lordship, I'm having a small instruction from the department.
Counter affidavit, have you filed? Not yet.
Not yet. But then, Lordship, considering the small thing of the matter, Lordship, may kindly peruse para 2 and 4 of this instruction.
Para 2 and 4 of? Okay. Yes, please read para 2.
Your Lordship, that with regard to the statements made in para 4, the deponent begs to state herein that the petitioners are entitled. That means the department is admitting that the less trons pay for the period January to February 2015. But due to financial burden of the state government, the department has not been able to pay in time. And para 4, Your Lordship, that with regard to the para 7 to 9, it is stated that in the given facts and situation, the deponent humbly prays that a certain time may be granted due to all the possible exercise for payment and release of less drawn that are entitled to the petitioners.
So you're just praying for time. You make it in the form of this thing, affidavit, isn't it?
Yes, yes.
Admitting. Because we are praying for time anyways, then
Yes,
some
yes,
more time will be
yes.
there. How much are you supposed to receive? What is the?
As per the record, Your Honor, it's 1,49,30,499.
That's a huge amount, isn't it?
And it is to be noted that the mechanical division, they've already been paid. Only the RNB, National Highway, into the housing, they've not been paid.
Okay, heard, Mr. So learned. Counsel appearing for the petitioner, state respondents, appearing for the state respondents, who submits that he has received instructions from the state respondents, and he may be allowed to file the counter affidavit, for which he needs some more time. We'll just make it like that. See in the meantime. Okay. Mr. So-and-so, you're Mr.
Sabumati.
Sabumati makes appearance on behalf of the petitioners. In view of the above, list this matter after
Lordship, 2 weeks.
4 weeks?
2 weeks, 2 weeks.
Okay, this is matter after 2 weeks.
Obliged.
Obliged.
For admission, item number 39.
Yes.
May I place your lordship? My lord, this date has been fixed with the consent of both the parties. But before my learned friend could make his submission, I would like to share some difficulties, lordship. In the second half, today I have some difficulties. And tomorrow is the DB day, Division Bench Day. So let it be come up day after tomorrow.
Yes, the petitioner.
Your Lordship, there is some urgency in this. Of course, day after tomorrow,
agree
it is
that,
not that long.
It is
but
equally
then
important for me also.
If we can start today, then
What
we
is
can
the matter
continue day
about-
after, day
Yes.
after, yes.
The matter
If we
is
can
with
start
regard to
today.
the revocation of the retirement order of the private respondent. Mistakenly, the government has issued a premature retirement order. And after getting the order, the private respondent has submitted a representation to the government stating the entire facts. And on consideration of my representation, government have realized about your mistakes. So the matter was referred to the PNAR department and the law department. And on the advice of these two nodal departments, the department has revoked my retirement order
Yes.
basing on the records, authentic records.
Oh,
And that is what we have challenged now by filing the writ petition.
okay, saying
So-
that you have to get your what? Pay.
No, no.
Then
I
what?
was made to retire prematurely before the actual time of
Okay,
retirement.
okay, yes.
By
Ah.
mistake, the government has issued a retirement order. Therefore,
Which
I
has
made the
been revoked.
representation.
Oh.
And then on verification of all the authentic records,
Oh.
government has rectified their mistake. And by filing rejoinder affidavit, the government has made it very clear that it is a mistake. Therefore, the mistake has been corrected. So by
That is
correcting a
not the true
mistake,
picture.
no
But once the
illegality
matter
has
is
been
heard
committed by
properly,
the state
Okay,
respondent.
we'll
Things
fix
should
a
be
short
clarified.
date then, day after tomorrow.
Yes, Lordship. Otherwise, it's a lengthy
Can we
matter.
start today so that we can continue day after tomorrow?
Let us maintain the continuity.
Right, yes.
In that view of the matter, Lordship, let it come on Monday because on Friday I have some pre-engagement, Lordship.
So you want it on?
Monday.
No, day after tomorrow is Thursday, not
Oh.
Friday. So we can start on the Thursday and then,
Well, on Thursday, can we start the matter on Thursday?
yes,
I have no difficulty.
Okay.
yes. Okay.
On the consent of both the learned counsels for the party, this matter may be listed on 20, is it 24, 2023? Yes, 24.
24.
Yes. 20 April
Yes.
2023. Yes.
For admission,
Your
item
Lordship,
number
let interim continue.
Okay, meanwhile, the interim order passed earlier shall continue.
And if it can be made first item,
No, we will list it. Let's see when it comes up. Okay.
for admission, item number 43.
43. Yes, affidavit in opposition by the state respondents.
Lordship, here the state is yet to receive instruction, Lordship. So Lordship may please to grant another 3 weeks time, Lordship.
Okay. 43 heard Mr.
Vijimomi.
V. Zimoni, Laureate Government Advocate for the state respondents, who has prayed for further time for filing of the affidavit in opposition. Ms.
K. Lilisu.
K. Lilisu appears on behalf of the petitioners. In view of the above, list this matter after 3 weeks.
I look at.
Yes. I think there's a supplementary list.
For admission, item number 53.
Yes, 53. Who is appearing for the petitioners?
Lordship, just 1 minute, he's coming.
Who's coming?
My learned friend is coming. Just 1 minute, Lordship.
Okay.
Mr. Iralus, I think he may just be outside. If I may pass over this document, Your Lordship, as undertaken yesterday, I've informed both the Standing Council as well as the Council for the Petitioners. How can I pass it over, Your Lordship?
Someone will come. Oh, I think they've just left the room for 5 minutes.
Your Lordship, I draw your attention to the previous order once more.
Wait, can we wait for some time? Because I have a feeling the file has not been.
Sure, Your Lordship.
It's been misplaced. I don't have the concerned file. with me. Yes. Yes, it's okay. Ah. Now, in this IA, it says that yes, which order? 23? Dated which order?
2023, Your
Yes.
Lordship. It is considering, I had requested and as recorded, I had requested for the application to be considered as a counter affidavit to the writ.
Okay.
And the matter was posted for final hearing, so I would like to please press on that, Your Lordship.
Okay. Yes.
The matter is quite simple, Your Lordship, but in a very unfortunate and a very backhanded manner, advantage had been taken of this court to, in effect, steer central legislation before a single bench by alleging that the enforcement order of the state, the notification of the state, is countenance to the rights of the petitioner. Whereas the notification of the state is merely an enforcement order of a central legislation. And the petitioners may claim ignorance, Your Lordship, but in the petition there is replete mention of that specific regulation that is applicable. Regulation 2.5.1A of the Food Safety and Standards, Food Products and Food Additives Regulations of 2011 define animal. What is a food animal? Read with the definitions of food within the Food Safety and Standards Act.
Let's come from the beginning. There was
Yes,
a
Your Lordship.
notification which is passed. Where's the notification?
Lordship, are we taking up
Your
the
Lordship,
matter?
the notification is
I can
at,
begin with the subject. I'm for the
Yes,
petitioner.
no, yes. So
She's
the
for the respondent
petitioner
and I
has
can
to
also
start the case. Yes. Let's
Yeah.
come to the facts of the case. What happened?
In this petition, the challenge is laid on a notification issued on 4th July 2020, by which the state government has imposed a ban on the import, trading, and the sale of dog and dog meats in the state of Nagaland.
Okay, where's that notification?
It's at page 50 of the writ petition.
Yes. Page 50, 50?
Yes, 50, annexure A6.
One minute.
That is the type
Wait,
copy.
wait, yes, I'm looking at the IA.
Yes.
So let me.
Page 50. as your lordship found it.
Wait just a sec. Yes. Page 50 of the petition. Yes, yes, go ahead.
Uh, May I be allowed to read
Yes.
the entire notification? Subject: ban on import and sale of dog meat in the state. 1. Whereas the central government, Ministry of Health and Family Welfare, has enacted the Food Safety and Standards Act 2006, Act for short, and the Food Safety and Standards, Food Products Standards and Food Additives Regulations 2011 to regulate the safety of food articles safe for human consumption. 2. And whereas in Regulation 2.51A of the FSSAI Regulation 2011, meat and meat products, and as per Regulation 2.5.1A of the Regulation 2011, animal means an animal belonging to any of the species specified below. 1. Ovines, 2. Caprines, 3. Suilines, bovines, and includes poultry and fish. And whereas the slaughtering of any other species other than the ones listed in sub-regulation 2.5.1A of the regulation is not permissible under the FSS Act and Regulation 3. And whereas for strict compliance of the FSS Act and Regulation, and in order to regulate the safety of food articles safe for human consumption, it is necessary to ban slaughter and sale of dog meat in the state of Nagaland. 4. Now, therefore, in consonance with the provisions of the FSS Act and Regulation, the following are banned with immediate effect. A. Commercial import and trading of dogs and dog markets. B. Commercial sale of dog meat in markets and dine-in restaurants. 5. Any person found violating this order shall be liable to be punished under Section 428 and 429 of the Indian Penal Code 1860 and Section 11 of the Prevention of Cruelty to Animals Act 1960 and or any such provision of law as may be applicable. This shall be enforced by the district administration, police, municipal administration, and the veterinary and animal husbandry department severally as well as jointly. This is issued in pursuance to the approval of the cabinet memo dated 4th July 2020. So my primary contention in this, as far as the notification is concerned, is that the regulation of 2011, if I may be allowed to refer to it as the Food Products Standards Regulation. The Food Products Standards Regulation. This regulation does not expressly or impliedly provide any provision where apart from the animals, the species of animals which are listed under the definition of animals, no other animal can be consumed by the citizens of India. And the interpretation adopted by the Food Authority, that is the Food Safety and Standards Authority of India, as well as the state government, is not in consonance with the primary act, that is the Food Safety Act of 2006. That is the primary contention in this writ petition.
Wait. And whereas the slaughter of any other species other than the ones listed, you're saying
Yes,
this?
yes. And yes.
In sub-regulation, is not permissible under the
Yes.
FSS Act.
This is a construction which has been employed by the Food Safety Authority as well as which has been adopted by the state government. But my contention or my argument is that this construction, this interpretation has only been adopted by them. There is no provision
By them means?
by the Food Safety Authority and the state government.
Okay,
There
what
is
does
no-
the Act say?
I'll take your lordships to the act as well as the regulations as well as the other relevant acts which may be relevant, which may fall for your consideration, for the consideration of this court. Your lordship may have the Food Safety and Standards Act 2006. Before that, if your lordship may allow me to delineate the four grounds, the four main contentions which I'm taking in this petition.
Okay, number one
Yes.
is this
Number one
regulation.
is-
That is FSSAI regulation, is it?
Yes.
FSSAI regulation, okay. It's not in conformity with the Food Safety Standard Act.
No,
Is that
no.
your point?
No.
Then?
That the interpretation advanced by the Food Authority, that is the Food Safety and Standards Authority of India,
Okay.
and the
Where's the interpretation made by them in the regulation?
yes, in the regulation.
Yes,
I'll show
yes.
your lordship that,
Yes,
that
yes,
aspect.
yes.
But yes, if your lordship may have page 26 of the petition.
26.
Yes. This is my first contention. Contention 1.
Yes.
Condition 1. Neither the Act nor the regulation, that is the regulation that is under reference, specify that animals not included in a definition of animal under Regulation 2.5.1a are prohibited from being slaughtered for human consumption. I'll make necessary submissions in this regard. This is the first contention. The second contention is at page 33. Page 33. Contention 2. Respondent number 1, that is the Chief Secretary, has no authority to issue the impugn notification under the Act. That is the second contention. I'll make necessary submissions. The third contention is page 36. The contention 3. The impugn notification is not issued in accordance with the procedures and principles prescribed in the Act and in violation of principle of natural justice. That is the third contention. And the fourth contention is page 37. Even assuming the Act and its regulation has no application, the executive government has no competence to pass the impugn notification. So these are the four main contentions on which I would like to make necessary submissions. Firstly, if your lordship may have page 14 of my petition.
1-4.
Yes, 1-4. At page 14, paragraph 5 and these following paragraphs, I have extracted some of the earliest ethnographical and anthropological accounts of the Nagas, wherein the customs of eating dog meat has been recorded. So at paragraph 5.1, your lordship will find the book on the Angami Nagas with some notes on neighboring tribes by J.H. Hutton. He was a former Indian civil service, and he was also the deputy commissioner of the then Naga Hills. In his book, at page 81, at subpara A, it has been reflected that dogs are eaten in great numbers at the Sekini Gena, probably on account of a belief in the medicinal properties of dog's flesh. Secondly, B. Beef, pork, and chicken are no doubt his commonest meat food, and these are supplemented by meat. It should be mitun, and dog on occasions, and even by cats. While all wild animals and birds are eaten, even crows. Page 197 and 198, there will be C. Sekrengi. This is a festival of the Angami tribes. The men have to eat separately, taking their food away from the hearth and remaining chaste for at least 3 days. Dogs are eaten in large number. Again, another account where the dogs are being eaten has been recorded. So this is for the Angami Nagas, Angami tribes of the Nagas. That paragraph, I will not be reading on all the paragraphs, but just for the for this court's consumption only. The page at paragraph 5.2 is the J.H. Hutton's account on the Sema tribes, the Sema Nagas, published in 1921. Again, where it has been recorded that dogs are eaten even by these tribes also. Paragraph 5.3. J.P. Mills, again another ethnographer, and in his book, The Ao Nagas, he has also recorded how the dogs are eaten. And at paragraph 5.4, J.P. Mills, in the other book pertaining to the Rengma tribes of the Nagas, the Rengma Nagas, published in 1937, again he has recorded how the Rengma tribes, they eat dogs and how they treat it as medicine also. Even though these accounts have been provided in this petition, my humble submission is that since I'm not challenging the regulation as such, it is only for the consumption of this honorable court that the custom of eating dog meat has been prevalent, maybe even before these accounts were recorded, but these were the first historical accounts of the Nagas, as far as history is concerned. So it is only for this honorable court's reference that I have provided these documents. I have not been able to provide the book, but the archive, where the books are recorded on internet, has been provided in the footnotes. Now I'll come to the main act, that is the Food Safety and Standards Act 2006. This act was, Your Lordship may have the preamble.
Yes. The act.
Yes, page 4, the preamble.
Yes.
An act to consolidate the laws relating to food and to establish the Food Safety and Standards Authority of India for laying down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale and import to ensure availability of safe and wholesome food for human consumption and for matters connected therewith or incidental thereto. This act was enacted by Lordship, may kindly have page 71 of the Bear Act, page 71. Second schedule, page 71.
Yes.
Yes, in this second schedule, a list of enactments have been provided.
Page 71.
71,
Yes.
under second schedule. This is to be read with section 97. And this Food Safety Act has repealed all this and has consolidated all the laws which are contained in all these enactments into one act, that is the Food Safety Act. Now, Your Lordship may kindly have the definition of food. Section 3J.
Yes.
3J.
Section 3.
3J.
J.
J.
Okay.
I'll read it.
Yes.
Food means any substance, whether processed, partially processed, or unprocessed, which is intended for human consumption and includes primary food to the extent defined in clause ZK, genetically modified or engineered food, or food containing such ingredients, infant food, packaged drinking water, alcoholic drink, chewing gum, and any substance, including water, used into the food during its manufacture, preparation, or treatment, but does not include any animal feed, live animals, unless they are prepared or processed for placing on the market for human consumption, plants prior to harvesting, drugs and medicinal properties, cosmetics, narcotic or psychotropic substances, provided that the central government may declare by notification in the official gazette any other article of as food for the purposes of this act, having regards to its use, nature, substance, or quality. So, in essence, this is the exhaustive definition of food, which has been provided by the Act. Now, Your Lordship may have, since the primary definition of food is in the first part, which is food means any substance, whether it can be processed, partially processed, or unprocessed, and which is intended for human consumption. Your Lordship may have the definition of substance at section subclause ZW. Subclause ZW.
Yes.
Yes. Substance includes any natural or artificial substance or other matter, whether it is in a solid state or in liquid form or in the form of gas or vapor. So my first contention is that the meat of dog it is a solid substance, and it is and therefore it is a food. Now the inclusion part, and includes, the definition says it includes primary food, which is to the extent defined in clause ZK. So, Lordship may have the clause ZK.
Yes.
Clause ZK.
Yes, go ahead.
Primary food means an article of food being a produce of agriculture or horticulture or animal husbandry and dairying or aquaculture in its natural form, resulting from the growing, raising, cultivation, picking, harvesting, collection, or catching in the hands of a person other than a farmer or a fisherman. And as far as the other words are concerned, no other definition is provided. But my contention here, my general or broad-based contention is that since food includes any substance, food means a substance, which it can be processed, partially processed, or even unprocessed. The meat of dog is food.
Okay.
Now, the Lordship may have the contentious regulation now, which is at page 196.
Page 196.
196 of the Bayer Act, yes.
Of?
The Bayer Act.
Okay. Which is what?
This is the contentious regulation, that is the food safety and standards, in bracket, food product standards and food additives regulations 2011, under which the
Okay,
definition of animal,
regulations,
yes,
yes.
has been provided. I'll just read the
Regulations 2011.
Yes. The first intro I would like to read. Whereas in exercise of the powers conferred by Clause E of subsection 2 of Section 92, read with Section 16 of Food Safety and Standards Act 2006, the Food Safety and Standards Authority of India proposes to make food safety and standards regulations insofar as they relate to food safety and standards, food products standards, and food additives regulations 2011. And in this manner, this regulation was enacted under Section 92(2)(e), read with Section 16 of the Act. Before coming to the clauses, the regulations, maybe it'll be profitable if we go back to Section 92, Section 92(2)(e) of the Act. Section 92, it says, power of food authority to make regulations. The food authority may, with the previous approval of the central government and after previous publication, by notification, make regulations consistent with this act and the rules made thereunder to carry out the provisions of this act. 2. In particular and without prejudice to the generality of the foregoing power, such regulations may provide for all or any of the following matters, namely, since we are concerned with subclause E, I'll just read out that only. Notifying standards and guidelines in relation to articles of food meant for human consumption under subsection 2 of Section 16. So, Your Lordship, may kindly note the words standards and guidelines, notifying standards and guidelines. Now, Section 16. This is Section 16 prescribes the duty of the food authority. Duties and functions of food authority. It shall be the duty of the food authority to regulate and monitor the manufacture, processing, distribution, sale, and import of food so as to ensure safe and wholesome food. Now, this is the primary duty, and under subclause 2, without prejudice to the provisions of subsection 1, the food authority may by regulation specify under which various clauses have been mentioned. And at clause A, Your Lordship will find the standards and guidelines in relation to articles of food and specifying an appropriate system for enforcing various standards notified under this Act. I would also like to take Lordship to subclause I, the manner in which and the procedure subject to which risk analysis, risk assessment, risk communication, and risk management shall be undertaken.
Yes.
So I may not need to read the entire clauses, but if under 16.1, it prescribes that the duty of the food authority is to regulate and monitor. I'm putting emphasis on the word regulate. To regulate and monitor the manufacture, processing, distribution, sale, and import of food, so as to ensure safe and wholesome food. So based on these two sections, 92(2)(e) and 16.2, the regulation, the contentious regulation, that is the food safety, food products standards regulations of 2011 has been enacted. And before I dwell on the regulations of 2011 and the various regulations under this regulation, Your Lordship may have the clause sorry, the regulation 2.5, under which the definition of animal has been provided. Page 301.
301.
301. 2.5. The heading, it reads meat and meat products.
Okay, this is regulation 2.5. Huh?
2.5. Has your lordship found it?
Yes.
2.5, the heading reads meat and meat products.
Yes.
Under 2.5.1 is the definition clause, and sub-regulation A defines animal. I'll
Yes.
allow me to read this.
Yes.
Animal means an animal belonging to any of the species specified below. Ovines, caprines, suilines, bovines, and includes poultry and fish. Oh, this term ovine, it relates to sheep, goats. Sorry, sheep. Caprines, it relates to goats. Suilines relates to pig or pig family, and bovines relate to cattle. I have made that agreement under page 25 of the writ petition. Yes. And before proceeding any further, your lordship may also like to have a notification. At page 54 of my writ petition. Page 54, annexure A7. This is a gazette notification by which, at page 56, the English version,
Yes.
the species of domestic rabbits was added.
Page 50?
56.
56,
By
yes.
notification dated 12 September 2017. Yes. At
yes.
Yes, at section 2, in the food safety and standards, food product standards and food additives regulation 2011, in regulation 2.5, in sub-regulation 2.5.1, in clause A, after item 5, that is, item 4,
Yes.
the following items shall be inserted, namely, number 5, that is domestic rabbits, and the scientific name has been inserted. Yes. Now, this is
Yes, this is domestic rabbits.
yes. So this bear was published prior to this notification. So I just wanted to point it out before this got that.
Okay, this is 2017.
Yes. Yes.
Before the notification, yes.
So now domestic rabbits has also been included under the definition of animals. And it is only from this definition that the Food Safety Authority or the Food Authority and the state government, they bring out the interpretation that since under the definition of animal, the item dog or dog meat is not included, that the citizens or the public in Nagaland cannot eat dog meat. That is the primary interpretation or construction which have been forwarded by the Food Authority and which has also been adopted by the state government,
Okay.
eventually leading to the impute notification.
Oh.
And my contention is that there is no express or implied provision in the act or even in this regulation where for any species of animals not found in the definition of animal, the public cannot eat or it is not feed for human consumption. And for that, your lordship may have to bear with me, but since the regulation assumes prime importance in this matter, to understand why this regulation was enacted, the regulation of 2011, I may also need to briefly take your lordship to all the regulations to understand the import of the regulation as to for what purpose it has been enacted. And I'll try to be as brief as possible, but I'll briefly refer to some of the try to be as brief as possible.
Yes.
It starts at 196 again, page 196.
Of the Act.
Yes, of the
196.
regulation. The regulation.
196.
So this
Yes.
regulation, as I've already shown before this court, that it was enacted under by exercising power under section 92(2)(e and read with section 16.
Yes.
Where my emphasis is laid on the notifying the standards and guidelines. And my contention is that this regulation is only for the purpose of maintaining those standards and guidelines for the food business operators under the Act. If they are going
Those
to
that are mentioned in the
yes,
Act.
yes.
Okay.
If they're going to sell, manufacture, process, or do anything with all the food, with any of the food articles mentioned in this regulation.
Oh.
And for
So you're saying this regulation is only for those items mentioned in the Act?
yes, no,
Okay.
mentioned in the regulation.
No. Okay, in the regulation.
regulation, in
Okay,
the regulation.
okay.
So in the regulation, your lordship will find many of the food articles. It's very technical regulation, but chapter your lordship may have the first part is regulation 1.2 concerns the definitions. Regulation, I'll skim along. Regulation 2.1, page 199. It deals with chapter 2.
Yes,
Chapter
dairy
2,
products.
Food product standards, dairy
Yeah.
products and analogs. 2.1.1 milk, and then your lordship may come to 2.1.2 cream, and before just one paragraph I may be allowed to read.
Milk, where?
Page 203. Milk, 2.1.2 cream. One says cream, including sterilized cream, means the product of cow or buffalo milk or a combination thereof. It shall be free from starch and other ingredients foreign to milk. It may be of the following three categories, namely 1, low-fat cream. I'll skip the other one. 2, main fat cream, medium fat cream. 3, high-fat cream. Number 2, cream powder means the product obtained by the partial removal of water from cream obtained from milk of cow and or buffalo. The fat and or protein content of the cream may be adjusted by addition and or withdrawal of milk constituents in such a way as not to alter the whey protein to casein ratio of the milk being adjusted. It shall be of uniform color and shall have pleasant taste and flavor, free from off flavor and rancidity. It shall also be free from vegetable oil, fat, mineral oil, added flavor, and any substance foreign to milk. So it's quite technical, but these are the contents of the sub-regulations.
Yes.
Now, 2.1.3 deals with malai. 2.1.4 deals with dahi or curd and how it is to be manufactured or processed. Next, 2.1.5 chena or paneer and how it is to be processed. Is your lordship with me?
Yes, go ahead.
Okay.
I'm just
2.1.6
looking at something else.
deals
Yes.
with cheese
Yes, go ahead.
and all other milk products under regulation 2. Now regulation 2.1. I'll come to 2.2 now.
Okay, first one is milk products.
Yes.
Then 2.2 is what?
2 is
Dairy products, desserts.
two-
Then 2.2 is what?
at page 235. Fats, oils, and fat emulsions.
Yes.
2.2.1 oil. Oils, I may be allowed to read one.
Yes.
Coconut oil means the oil expressed from copra obtained from the kernel of cocos, nucifera nuts. It shall be clear and free from rancidity, suspended or other foreign matter, separated water, added coloring or flavoring substances, or mineral oil. It shall conform to the following standards. And again, the technical requirements. Now, next, under fats and emulsions, we have your lordship may come 2.3 instead.
Hmm.
2.3 at page 261. This is it deals with fruit and vegetable products.
Yes.
Thermally processed foods. The product number 2, the product may contain food additives permitted in these regulations and appendices. The product shall conform to the microbiological requirements given in Appendix B. Drain weight of fruits shall not be less than the weight given below, so and so. And then 2.3.3, next page, page 262, 2.3.3.
Yes.
Thermally processed vegetables. Term number 1. Thermally processed vegetables in bracket canned, bottled, flexible pack, aseptically packed means the product obtained from fresh, dehydrated, or frozen vegetables, either singly or in combination with other vegetables, peeled or unpeeled, with or without the addition of water, common salt and nutritive sweeteners, spices and condiments, or any other ingredients suitable to the product, packed with any suitable packing medium appropriate to the product processed by heat in an appropriate manner before or after being sealed in a container so as to prevent spoilage. I'll read that much on that. And then 2.2.4 again deals with thermally processed curried vegetables, ready-to-eat vegetables, and how to process them, how to pack them, how to preserve them. Those are the technical requirements. And then 2.2.6, thermally processed fruit juices, how to process, how to pack, how to add additives, and all the other technical requirements are mentioned in this regulation. And the standards which the food business operators has to follow while selling them or manufacturing or processing them. Now, your lordship may have 2.4 now. That'd be at page
Yes.
284. Cereals and cereal products. Again, 2.4.1 deals with atta, how to process, how to manufacture. 2.4.2, 286 page, deals with
Yes.
maida. 2.4.3 at page 286b.
Yes. Okay. I'm getting your point. It's very technical how to
Yes.
preserve.
Semolina suji, that is orawa.
Yes. Yes.
And then again here,
Yes, I'm getting your point. It's very
yes,
technical how they are to be
yes,
preserved. So, is
yes.
there anything about meat here? No. We're dealing with dog's meat.
No,
So,
yeah.
anything here? Nothing.
And then,
There's something with meat
yes, and then
concerning
comes regulation 2.5.
2.5.
Yes, that deals with meat
Oh.
and meat products.
Oh.
So here the definition of animal is provided.
Hmm.
And at clause subclause B, it says carcass. But again, carcass meat, C defines meat, D defines meat food products, but in relation to the definition provided under clause A, animal. Any reference to animal under subclause B, C, or D, any reference to animal would mean the animal under this
A, B,
subclause
C,
A.
and D.
Yes.
Okay.
Your lordship may have subclause D, meat food products.
Oh.
Meat food products means any article of food or any article intended for or capable of being used as food which is derived or prepared from meat by means of drying, curing, smoking, cooking, seasoning, flavoring, freezing, or following a method of processing meat akin to any of the above methods, but shall not include the following products. So it mentions the products which are not included in meat food products. Clause E also defines slaughterhouse. Clause E defines slaughterhouse to mean the building, premises, or places which is licensed as a slaughterhouse by the local authority for the slaughter of animals intended for human consumption. Now, regulation 2.5.2 deals with meat and meat products. Now, since this is the relevant regulation, I may be allowed to read 2.5.2 clause 1. Canned deals with canned corned beef. Canned corned beef means the product prepared from boneless meat of carcass of bovine animals, including buffalo meat, which have been subjected to ante-mortem and post-mortem inspection. The product shall be uniformly cured with edible common salt and sodium and/or potassium nitrate. The product may contain ascorbic acid, sodium ascorbate, or isoascorbate acid / sodium isoascorbate, singly or in combination, not exceeding 500 mg per kilo. The product may also contain sucrose, dextrose, dextrose, maltose, and glucose syrup, including corn syrup. Next, the product shall be packed in hermetically sealed containers and subjected to heat treatment, followed by rapid cooling to ensure that the product is shelf stable. The sealed containers shall not show any change on incubation at 35 degrees Celsius for 10 days and 55 degrees Celsius for 5 days. Next, the product shall be in the form of a solid pack capable of being sliced. The product shall be free from any added color and natural and artificial flavor. The product shall be clean and substantially free from staining and contamination from the container, foreign matter, and objectionable odor. So it lists the requirements, the ingredients, the next table. 2, the clause 2, deals with canned lunched on meat. Canned lunched on meat means the product prepared from edible portion of meat of mammalian animal slaughtered in an abattoir, which have been subjected to ante-mortem and post-mortem inspection, and or edible meat of poultry birds, including chickens, turkeys, ducks, geese, guinea fowl, or pigeon, slaughtered in an abattoir. So again, it deals in the same manner as it dealt with canned corned beef, how to pack, what ingredient not to use, what additives to use. The same is followed. 3 deals with canned cooked ham or pork products. 3, canned cooked ham.
Yes.
Means the product prepared from meat of pigs, which have been subject to ante-mortem and post-mortem inspection. The product shall be free from bones, detached cartilage, tendons, ligaments, and may be with or without skin and fat. The product shall be uniformly cured with edible common salt and sodium and potassium nitrate. The product may contain sucrose, invert sugar, dextrose, lactose, maltose, glucose syrup, including corn syrup, honey, spices, seasoning, and condiments, water-soluble hydrolyzed protein, and food-grade gelatin. The product may be smoked and flavored with natural flavoring substances and nature-identical flavors, as well as permitted flavor enhancers. The product may contain ascorbic acid, isoascorbic acid, and its sodium salt, singly or in combination not exceeding 500 mg per kilo, expressed as ascorbic acid, sodium and or potassium monodipolyphosphates, singly or in combination not exceeding 3000 mg per kilo, expressed as P2O5, as antioxidant and water retention agents respectively. The product may also contain sodium potassium alginate, not exceeding 10 mg per kilo
Yes,
and or
this
agar.
is concerning
Yes,
canned
again,
food. Then
My
four,
lady.
4 deals with canned chopped meat in the same
Yes.
manner,
So
and
again, 5 is
canned chicken.
So this is how to count the
6
things.
and
Yes.
7
So
frozen
then
mutton,
next
chicken,
is
goat.
fish and fish
Now,
products.
yes, that's the regulation which
Gives
deals
you,
with meat and
okay,
meat
how to
products.
take care of the meat.
Yes.
And how to can it. Yes.
But in order to have a generalized and a broad view of
Yes.
what these regulation means,
Yes,
it may be also be beneficial to refer to 2.6, which deals with fish and fish products.
Yes.
I'll not be reading, but it deals with fish and fish
Okay,
products. The
right.
food articles are mentioned therein. And then 2.7, come to page, if you lordship may come to
Yes,
page
sweet,
310.
sweet
Yes,
and
sweet and
this.
confectionery. And then
So
2.
you are trying to point out what the regulation is all about.
Yes.
Yes.
And it is only to notify or to maintain the standards and the guidelines prescribed by the as required by the Act.
Yes.
And nowhere is there any provision where for non-mentioning of any food article under the definition of animal, that such article cannot be consumed or such article is not meant for human consumption.
Okay. Okay. So this regulation is cannot be used for notifying. You're saying.
Yes,
Okay.
that is basically the submission. Um, Your Lordship, may kindly pardon me for one. Your Lordship may recall that this act was enacted by repealing various enactments, by repealing various existing enactments then, and compiling all of such enactments into one called the Food Safety Act. Now, under second schedule is is one enactment called the Meat Food Products Order, and I have supplied a copy. This now has been repealed, but for the purpose of reference, under second schedule, if your Lordship may kindly have that second schedule of the Act. In this meat
Yes.
food products order, I may be allowed to read the first one. In exercise of the powers conferred by Section 3 of the Essential Commodities Act 1955, the central government hereby makes the following order, namely, this order may be called the Meat Food Products Order 1973. Now, in this, your Lordship will see the definition of animal under
Yes.
Section 2.
Yes.
Order 2. In this order, unless the context otherwise requires, animal means an animal belonging to any of the species specified below. Ovines, caprines, suelines, bovines, and includes poultry and fish. Again, this definition has been adopted in the regulation now. Same as it was.
Yes.
And when this order, the Meat Food Products Order, was in existence then in 1973 till 2014, or even 2020 till the issuance of the MP notification, no other notification was issued, neither by the central ministry, by the food authority, or even the state. But only in 2014, there was a circular, which I've also impugned in the writ petition, where the food authority has directed or requested the state food commissioners, saying that since dog meat is not provided, or no animal which are not found in the definition of animal, such animal cannot be meant for human consumption. Such direction was issued only in 2014.
Okay.
Prior to this, no such information is available. No such affidavit in the affidavit.
What is the 2014 thing you're mentioning?
Yes, my apologies. But
So your point is this regulation, 2011 regulation,
yes,
is only for processing of the food. Is it?
yes, as the name itself suggests,
Of the food.
food product standards.
And then you had the previous one that was repealed, that is 1973.
Meat
which
Food
is
Products
also,
Order.
yes, processing of food.
Yes, again in the same in this order.
So you're saying the regulation is how to process the following meat items.
Yes.
Okay. Then what is the 2014 notification?
This, your Lordship, will find at page. Okay, page 58.
58 of what?
58 of the writ petition.
Oh.
Annexure A8, last page.
Yes.
This is dated 6th August 2014. Subject: slaughtering of animals not permissible under the FSS Act and regulations. Your kind attention is invited towards Regulation 2.5 of the FSS Food Products Standards and Food Additives Regulation 2011, wherein definitions of animals, carcass, and meat are given. As per sub-regulation 2.5.1a, animal means an animal belonging to any of the species specified below. Again, list out the ovines, caprines, suelines, bovines, and includes fish and poultry and fish. The slaughtering of animals of any other species other than the one listed above is not permissible under the FSS Act and regulations. Now, this interpretation has been borrowed by the state government in the impugn notification.
Okay. So you're saying this interpretation is wrong?
I'm saying that this is wrong and this is erroneous. This is patently erroneous, and this does not serve the purpose of the Act. In view of the above, you are requested to kindly strengthen the vigil and ensure the compliance of the provisions of FSS Act. So apparently, this can be maybe
Okay, so this is to all the
Food Safety
commissioners.
Yes.
So this notification issued by the state is also based on this?
Yes, it's based on this only.
Okay. So this is to the Food Safety Commissioner. Oh, okay.
So each state has a food safety commissioner. And
Now it's time for lunch break.
Oh, okay.
I think that is your first point.
Not yet. Yeah,
Not
but that is the first
completed.
point. I'm on my first contention.
Yeah, your
which is the
first
primary
contention.
Yes.
So have we completed? We'll continue after two.
All
At
right.
two.
All right.
Okay.
Your Lordship, I just want to express that it will be difficult for me to continue tomorrow. So I hope that we can
Let's see how
conclude
long it
the
will take.
matter
Isn't
today.
it? This will have to fix another long date or when you can come again. Let's see.
It'll take
We'll
some time.
continue
The-
at two first. Let him finish first, anyways, isn't it? Yes. We'll continue at two. Actually, you knock on the door. You don't have a calling bell. Okay.
Oh, we have a break. Break. We're going to continue at 2.
Now, how long is the argument going to take? You see, there's this continuation of the Diamond Jubilee celebration of the High Court.
Yes, yes.
And at 3 o'clock, I think we have some tree planting
Yes, I'm told.
program. Okay. So, I don't know, will you be able to complete? Then we'll have to give her also a chance. How long will your argument be?
Half an hour to 45 minutes, Your Ladyship, not more. I won't take more time.
But if it's 45 minutes, will you be able to complete your point?
1.5?
Huh?
1.5 hour?
Then we can't, I'll have to take part in the celebration tree planting thing. In fact, it's supposed to start at 2:30.
Or is it?
But they are willing to wait for me till
Okay.
3. Can we continue tomorrow? Stay back another day?
If your lordship has no, because tomorrow is a division bench matter, division bench day. So, but if your lordship is inclined on taking up the matter, then maybe we can proceed.
After the division bench?
Yes, yes.
It's little difficult for me, Your Lordship, but going and coming back would be more difficult. So I will concede. I will be here tomorrow.
Because we have heard so much. And if we make it part heard, I don't know when I'm going to sit again. Isn't it? Unless we make it next week.
Already next week will be difficult.
Difficult. Okay. Okay, then we'll hear till 2:45.
All right.
Okay, so you have finished your first contention, isn't it?
Not yet, Your Lordship.
Okay.
Not yet.
So your basic point in the first contention, I think it's clear now.
Under the first contention, I have 4 points.
Ah.
I'm slowly covering them.
Okay.
Yes.
First contention, 4 points. Number 1 is that this regulation is only with concerning the processing and
Yes.
of the food materials which are mentioned above.
Yes, and
isn't
how to
it?
maintain the standards
Yes,
and guidelines.
maintenance of standards of the food
So
material.
that aspect
Yes.
is over.
Yes. Then
Now, the second point is your lordship has seen that this regulation has been enacted under section 92 2E, read with
Okay.
16. And this essentially incorporates the principle of delegated legislation.
okay.
So the regulation
Oh.
is principally a delegated legislation. And the act, the parent act, this is the Food Safety Act, has empowered the food authority to issue enactments to serve the purpose of the act. Now, your lordship must also be knowing fairly well that in the principle of delegated legislation, the delegatee, that is the food authority, is not empowered to act beyond the powers conferred by the act in such a manner so as to narrow or widen or restrict the operation of the act. Now, the submission is that if we are to accept the interpretation which has been forwarded by the food authority as well as the state government, then such an interpretation would amount to narrowing the scope and the operation of the definition of food.
Okay. You're
Yes.
saying this notification made by the food authority is narrowing the scope.
Yes, the scope of the
Okay.
act,
Uh-huh.
more specifically the definition of food. It's narrowing the operation because
Okay.
as my submission is that the definition of food is extremely wide enough to cover anything. And if you are to accept such interpretation as forwarded by the food authority and state government, then such the delegatee will be acting in contravention of the power conferred on it. Now, for that purpose, I would like to take your lordship to the Prevention of Cruelty to Animals Act. And also another principle is that the delegated legislation in this regard is the regulation must be consistent with other parliamentary acts also.
Okay.
So my submission now is that this, if we are to accept the definition of animals, or if we are to accept the interpretation forwarded by the food authority, saying that since the dog is not mentioned under the definition of animal, and so for which it cannot be, it's not meant for human consumption, then such an interpretation will be contrary to the definition of animals provided under the Prevention of Cruelty to Animals Act.
Okay. So you're saying that this definition of animals, okay, as per the regulation or as per the what food authority,
Yes.
They're not defining dogs as animals. Is it?
The definition exists, but it's the interpretation which I'm questioning.
Okay.
So if we were to accept the interpretation, then that interpretation will amount to violating the provisions of the Prevention of Cruelty to Animals Act.
Okay.
Now, Your Lordship, if Your Lordship has the Act, the Cruelty to Animals Act, Your Lordship may have the definition of animals under Section 2A.
Yes.
Section 2A.
Yes.
It reads, animal.
Yes.
Animal means any living creature other than a human being. That's it.
Okay.
Animal means any living creature other than a human being. So it would invariably or necessarily include dog also. Now, under Section 11 of the PCA Act, if I may refer to it as PCA Act, Chapter 3, dealing with cruelty to animals generally. Now, 11,
Yes.
it provides the acts of commission or omission which would amount to cruelty to animals. And I will not be reading out the entire section, but close Section 11, 1A to 1O deals with the various acts of commission and omission which would amount to cruelty. But if Your Lordship has the Section 11.3E, Section 11.3 first. 11.3 says nothing in this section shall apply to E. The commission or omission of any act in the course of the destruction or the preparation for destruction of any animal as food for mankind, unless such destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. So, in the process of preparing or destroying the animal as food, if any unnecessary pain or suffering is inflicted on a dog, in the insert case, then that will amount to cruelty. But if no such unnecessary pain or suffering is inflicted, then it would not amount to cruelty. Now, under the PCA Act, reading the definition of animal would necessarily include dog. Now, if I kill a dog under the PCA Act, in terms of the Act, then that would not amount to cruelty. If I'm to consume it, and if I'm to kill it properly as per the procedure prescribed under the Act, it would not amount to cruelty.
For food, yes. He says it's for food.
Yes. Therefore, under the PCA Act, the consumption of dog meat is not banned. There's no prohibition. Because animals includes any living creature other than the human being. So the consumption of dog meat under the PCA Act
Yes. Oh, yes.
is not prohibited. But the interpretation advanced by the respondents amounts to the effect that because the dog is not defined under Animals Act, the animals, we cannot eat it. But PCA Act says otherwise. Therefore, the submission is that the regulation is contrary to the PCA Act.
Interpretation of the
Yes,
regulation.
yes, the interpretation forwarded is contrary or contravenes the provisions of the PCA Act. And just for a quick reference only, under PCA Act, we have a Prevention of Cruelty to Animals Slaughterhouse Rules, which prescribes how animals are to be slaughtered.
Yes.
Prevention of Cruelty to Animals Slaughterhouse Rules. I will not be taking your lordships to the provisions, but generally speaking, it speaks about the maintenance of slaughterhouse, how to maintain a slaughterhouse, the veterinary inspection and everything. And it speaks about animals only. There's no prohibition on killing of any specific animal.
But what's this table? Okay, in page 24. Okay, this is table is Maximum load that can be taken. Okay. Okay, this is concerning the load that can be taken. List of animals has been given. Wait, where's the rules that you mentioned? What I'm looking at is prevention of cruelty to drought impact animals.
Uh,
Then prevention of cruelty to animals, licensings and ferries, the performing animals room, transportation of animals.
yes.
Which is the one that you mentioned?
The prevention of cruelty to animals slaughterhouse rules. Slaughterhouse rules.
Performing transportation of animals on foot. Okay, slaughterhouse rules, yes. This is 1921. 2020, 2001.
2001.
Yes.
It defines slaughter.
Yes.
Slaughter is defined as slaughter means the killing or destruction of any animal for the purpose of food and
Yes.
includes all the processes and operations performed on all such animals in order to prepare it for being slaughtered. So,
Yes.
yes, so the slaughter of a dog under the PCA Act, if it has been done without inflicting any necessary pain or suffering, such an act is allowed under the PCA Act.
Yes.
And the interpretation forwarded or advanced by the the respondents is contrary to the PCA Act. Under, just for a quick reference, if your lordship may have the Wildlife Protection Act also. Wildlife Protection Act. In this Wildlife Protection Act, it defines, it also has a definition of animal.
Okay.
Under section 2(1), and it defines animal as animal includes mammals, birds, reptiles, amphibians, fish, other chordates, and invertebrates, and also includes their young and eggs. That is it. And under section 2, clause 36, section 2, clause 36, we find a definition of wild animal. Wild animal means any animal specified in Schedule 1 or Schedule 2 and found wild in nature.
Yes. So is dog included there? No.
No,
Yes. Okay.
there's a
Now-
difference between domestic dogs and wild dogs.
Yes, yes.
And the Wildlife Act makes that difference.
Oh.
And I've also made that averment in my writ petition also, but just for your lordship's satisfaction, your lordship may also have section 9, where the prohibition clause is there. Section 9, hunting of wild animals. No person shall hunt any wild animal specified in Schedule 1 and 2, except as provided under Section 11 and Section 12. And then we may come to Schedule 1. Schedule 1.
Yes. Mammals.
That specific entry about wild dog is at Schedule 2, Part 1, Schedule 2.
But we're not talking about wild dogs, are we?
Yes, of course, but all right. But wild dog is mentioned, but what we are the instant case concerns domestic dogs only, not
Yes,
wild
I don't
dogs.
think it's wild dogs.
That's the point. That was just the point I wanted to make.
Oh.
And the other contention, the other ground under the main contention is that the domestic rabbits, which was included in 2017, that, as your lordship has seen, the regulation 2011 does not have any provision for domestic rabbits till now. There is no manner on how to maintain the standards and guidelines regarding domestic rabbits.
Okay. Yes.
Yes. So that it is submitted because of that. It is submitted that the regulation is only for prescribing the standards, how to maintain those
Okay,
standards, how to
okay.
notify the standard. The guidelines.
Mm.
Therefore, just because the rabbit, the domestic rabbits, and how to process, how to manufacture, how to market them is not mentioned, that is
Yes.
sufficient enough to indicate that that regulation is only meant for maintaining the standards and guidelines, as mentioned in section 92(2)(e).
Yes.
Yes. So, to conclude the first submission, on the first contention, I would like to just read out one paragraph from my writ petition at page 28. Page 28, paragraph 8.3.
Yes. Yes.
8.3. Therefore, it is submitted that if, by the mere definition of animal, it is to be presumed that other animals are excluded from being slaughtered for human consumption, then the definition of animal under Regulation 2.5.1a would be limiting the operation of the definition of food under Section 3J of the Act. The corollary of this, it is submitted, is that the delegate, that is the food authority, would be exercising powers exceeding and in contravention of the delegated powers. Therefore, the interpretation forwarded by the state is not sound and does not serve either the purpose of the Act or the regulation. So, under the first contention, the four propositions of law that I'd like to make is, if the interpretation of food authority and the state is accepted, that would amount to delegated legislation, that is the Food and Standards Regulation 2011, narrowing the scope of Food Safety Act by limiting the operation of the definition of food. That is the first proposition.
Yes, yes.
The second proposition is that if the interpretation of food authority and state is accepted, the definition of animal under Regulation 2.5.1a of the regulations would be contravening the definition of animal under Section 2a of the Prevention of Cruelty to Animals Act. The third proposition is that the definition of animal under Regulation 2.5.1a cannot be read into the definition of food under Section 3J of the Food Act. Cannot be read into.
Okay.
The fourth proposition is that definition of animal appearing in Regulation 2.5.1a has to be read only for the purpose of satisfying the purpose or the intention of the food safety standard regulation and nothing more. The intention of the legislature in enacting the act cannot be interpreted in the manner as projected by the state respondents. And the fifth proposition is that power of the food authority to regulate under Section 16 of the Act does not include the power to prohibit consumption of any food except according to the procedure laid down in the Act.
Okay.
Now, I would like to make some submissions on the contention number 2. That is, the respondent number 1, that is the Chief Secretary, has no authority to issue the impugned notification under the Act.
Okay.
Your Lordship may appreciate that under the Act, there are under two sections, the concerned authority can issue prohibition orders.
Okay. Yes. Food safety. Huh.
Yes, under the Act, prohibitions can be imposed under Section 30, Section
Okay.
33, and Section 34. But those are all subject to the procedures established under the Act. Once those procedures are satisfied, then only prohibition orders can be imposed, and that too only by the delegated authority, not the Chief Secretary. For that purpose, allow me to take your Lordships to the relevant
Yes.
provisions of the
30.
statute. First is Section 30.
Oh. Yes.
Section 30. Allow me to read. The state government shall appoint the Commissioner of Food Safety for the state for efficient implementation of food safety and standards and other requirements laid down under this Act and the rules and regulations made thereunder. 2. The Commissioner of Food Safety shall perform all or any of the following functions, namely A. A is the relevant one. I'm only prohibit in the interest of public health the manufacture, storage, distribution, or sale of any article of food, either in the whole of the state or any area or part thereof, for such period not exceeding 1 year, as may be specified in the order notified in this behalf in the official gazette. Subsection 3. The Commissioner of Food Safety may, by order, delegate, subject to such conditions and restrictions as may be specified in the order, such of his powers and functions under this Act, except the power to appoint designated officer, food safety officer, and food analyst, as he may deem necessary or expedient to any officer subordinate to him. So under subsection 3, the Commissioner of Food Safety can delegate such of his powers as may be deemed necessary to any officer subordinate to him. There's no mention of provision of delegating such power to the Chief Secretary. So under Section 31, it is more like a summary prohibition order. Section 33 deals, Section 33. Section 33 this has to deal with prohibition orders from the court. So it's, in my humble submission, this may be not relevant for the context of this petition, so I'll be avoiding that. And the other prohibition order is found at Section 34. Since this may have some relevance, allow me to read the entire section. Emergency prohibition notices and orders. If the designated officer is satisfied that the health risk condition exists with respect to any food business, he may, after a notice served on the food business operator, in this Act referred to as an emergency prohibition notice, apply to the Commissioner of Food Safety for imposing the prohibition. 2. If the Commissioner of Food Safety is satisfied on the application of such an officer that the health risk condition exists with respect to any food business, he shall, by an order, impose the prohibition. 3. The designated officer shall not apply for an emergency prohibition order unless, at least 1 day before the date of the application, he has served notice on the food business operator of the business of his intention to apply for the order. 4. As soon as practicable after the making of an emergency prohibition order, the designated officer shall require the food safety officer to A. Serve a copy of the order on the food business operator of the business, or affix a copy of the order at a conspicuous place on such premises used for the purpose of that business. And any person who knowingly contravenes such an order shall be guilty of an offense and shall be punishable with imprisonment for a term which may extend to 2 years and with fine which may extend to 2 lakh rupees. 5. An emergency prohibition order shall cease to have effect on the issue by the designated officer of a certificate to the effect that he is satisfied that the food business operator has taken sufficient measures for justifying the lifting of such order. 6. The designated officer shall issue a certificate under subsection 5 within 7 days of an application by the food business operator for such a certificate, and on his being not satisfied, the said officer shall give notice to the food business operator within a period of 10 days indicating the reason for such decisions. So these are the general provisions regarding the prohibition orders. The detailed provisions are further mentioned at the subsequent sections. Lordship, may kindly allow me to
Who is the designated officer, etc., isn't it?
designated officer at
Ah,
section
ah,
36.
ah, ah.
He's who he
Yes.
is, his function is mentioned.
Oh.
And then section 37 is the food safety officer.
Hmm.
The details, his functions, duties. 38 prescribes the powers of food safety officer.
Hmm.
And
Yes. So you're saying CS doesn't have these powers?
yes,
Isn't it?
and then after that, section 40.
Hmm.
Even section 40 allows, I'm sorry, before that, for paucity of time, I will not be reading the provisions of the powers of the food safety officer and the designated officer, but they have the power to inspect, to seize those articles of food if they are of the
Okay.
opinion that such is not safe for human consumption. The provisions are mentioned.
Okay.
And under section 40 also, the purchaser, that is the consumers, they can also get the food analyzed. Now, how to get the food analyzed is under chapter 8 at section 43.
Okay.
Analysis of food.
Hmm.
And then at section 45, section 45, the provision relates to food analysts who are to be appointed by the the food safety commissioner. Section 45, food analysts. And then section 46 prescribes the functions of food analysts. Since this has some relevance, allow me to read
Okay.
subsection 2 and 3.
Yes. 46.
Yes. The food subsection 2. The food analyst shall cause to be analyzed such samples of articles of food as may be sent to him by food safety officer or by any such person authorized under the Act. 3. The food analyst shall, within a period of 14 days from the date of receipt of any sample for analysis, send 1, subclause 1, where such sample is received under section 38, that is from the food safety officer, or section 47, that is also the food safety officer, to the designated officer, 4 copies of the report indicating the method of sampling and analysis, subclause 2, where such sample is received under section 40, that is by the purchaser, a copy of the report indicating the method of sampling and analysis to the person who had purchased such article of food with a copy to the designated officer. Now, again, the further procedures are prescribed in this section. Section 47 prescribes the sampling and analysis. How,
Yes.
again, entire procedure is prescribed.
So you're saying that this procedure was
None of
not
these
followed.
procedures have been followed this is my alternative contention or submission. If your lordship finds it the contention one satisfactory, or if my contention one satisfies this court, then the question of examining the other further contentions may not arise. But since these are alternative submissions, my contention number 2 is that the procedures which have been prescribed under the Act has not been followed. And that is why the appropriate authority to cancel is not the chief secretary, but it could be the food commissioner or even the designated officer, but subject to the provisions mentioned in the Act.
Yes.
And none of such procedure has been followed by the Act, and by violating the rights of the petitioners.
Yes. So contention number 2 and 3
2 and
is
3,
covered.
more or less, yes. Now, the fourth contention is that even assuming that the Act or even the regulation has no application, if the notification is to stand by itself, then such notification has no competence of law. It has not been backed by a legislature. The executive, in exercise of its executive function, cannot violate the fundamental rights of the petitioners under Article 19G and 21 without, in the absence of any law.
You're saying violating the rights under Article 19.
19(1).
19 is what? Your livelihood, trade.
G.
19(1)(g). So whose trade has been affected? Have you mentioned? How many traders are there?
1G. 191G.
Livelihood trade, or is it something like that?
Yes. Protection of certain rights regarding freedoms of speech. G says to practice
G.
any profession or to carry on any occupation, trade or business.
Yes. So are there any persons carrying out trade and business?
Yes, these are the
Where?
petitioners.
Who? The petitioners?
Yes.
Okay, the petitioners are persons who are carrying out trade
Yes,
in
yes.
selling of dogs
Selling
meat.
of dogs,
Is it?
dogs meat.
Okay.
In markets as well as dining restaurants.
So you're saying that the livelihood has been affected.
Yes.
Okay.
In addition to the absence of a law backing this notification, the other article that I'm relying on is Article 304 of the Constitution. 304, specifically 304B. 304, if I may be allowed to read.
304 is concerning rules, notifications, rules and all that, isn't it?
Restrictions on trade, commerce, and intercourse among states. Constitution.
Okay, 304.
Restrict 304.
Yes.
Notwithstanding anything in Article 301 or Article 303, the legislature of a state, it specifies the legislature, not the executive, may, by law, B, impose such reasonable restrictions on the freedom of trade, commerce, or intercourse with or within that state as may be required in the public interest. Now, again, my submission is that in the absence of any law, assuming the Act, the Food Safety Act, is not applicable in the instant case, the state of Nagaland has not enacted any specific law to prohibit the consumption or the sale, the import, sale, and the consumption of dog or dog meat in Nagaland. Therefore, as well, the impugn notification is ultra-vires the Constitution.
Okay.
And the final submission or the contention is that the petitioners, even though they may be dealing in the trade of dogs and dogs meat, they also consume, and they also know consumers who has the belief on the medicinal benefits of dog meat. Now, the submission is that this right to consume and the right to the belief that dogs meat has medicinal benefits. Scientifically, it may be true or it may not be true, but this belief is a facet of the right to privacy under Article 21 of the Constitution. Now, that is...
What? Right to privacy?
Right to it's a facet of the right to privacy under Article 21 of the Constitution of India.
Okay.
In order to substantiate my propositions, I have prepared a book list. However, I have prepared a book list in order to substantiate my propositions, but I think the court master is yet to bring the list of books.
List of
Books.
books.
Citations, authorities.
Citations,
Yes.
authorities, yes. Okay, you gave it to them a little bit late concerning authorities
Yes.
you want to cite. So I think you can continue tomorrow with
All
the
right.
authorities.
All right.
Is it? So the authorities will be based on what?
To substantiate those propositions and the contentions which I'm submitting.
Okay, no, the first which contention, first, second, third, or all the contentions?
All the contentions,
step by
all the
step?
contentions.
Okay. Oh. Even the state will have to say something, state respondent, isn't it? Nothing much to say in this, but it is the state who issued the notification, isn't it? But you have nothing to say about, nothing much. Have you filed here this thing, affidavit in opposition?
Yes, pleadings are
Okay.
completed.
Now, this notification was based, you say, on the cabinet decision. So, are we allowed to, are you going to produce as to the notes which led to the cabinet decision? I think memorandum
Yes.
has to be their cabinet
Yes,
memorandum.
it is in their counter affidavit.
It's there in their counter, how they came to the conclusion that this order should be. Okay, we'll have to look at that also. So we'll this thing conclude.
Your Lordship,
tomorrow. Yes.
if I may take 5 minutes, seek your indulgence. Can I seek your indulgence for 5 minutes, Your Lordship? I'll just go over the overview of the submissions that I would like to make.
But you can do it tomorrow.
If Your Lordship would be pleased to have it in the first half of tomorrow.
Let's see, tomorrow it's DB first. But I don't know if you're going to have any hearing for the DB. I've not seen the list yet. Okay. So it depends on the advocates, on the councils, whether they're going to pray for adjournment. A lot depends on the adjournments that are prayed for as to how busy we're going to be tomorrow.
Yes, Your Lordship. My only difficulty is that it takes me an entire day to travel, and I'm compelled to appear before the Delhi High Court day after. So if we could conclude it tomorrow, then
Yes, so we'll try and conclude it tomorrow.
Thank you, Your
However,
Lordship.
if you're going to have a case day after tomorrow in Delhi,
No, I need to be there for the briefing, Your Lordship.
then you can make it. You
So
can
I
make
have
it in one
only
day.
tomorrow.
From the Dimapur, you travel to
Delhi.
there must be a flight.
There's a 6-hour flight, Your Lordship, but that's all. If we can conclude it tomorrow, thank you, Your Lordship. Thank you so much.